Good evening and welcome to Three Hair Court Insolvency Webinar Series. I'm here with James Gale. I'm Simon Davenport, and we are going to be talking and focusing on principles of law and good practice with references to three leading cases in respect to the topic selling assets at the right value. The three cases that we will be focusing on are Davian Money, Devon Commercial Limited, and One Blackfriars Limited. I was in those cases and a number of other similar sale at undervalue cases. And in One Blackfriars Limited, which we'll hear about, Tom Poole was my junior, and James at the time was Tom's pupil, and now he's a full tenant here. This webinar, by the way, will be recorded, and both the recording and the script will be available online through our web link shortly afterwards and on demand from our clerks. That means you don't have to scribble away at sort of a rate of knots, because we will go quickly to cover a lot of ground. We hope you enjoy it, and we hope that we find it fruitful. We'd be very grateful for any feedback that you give to us. And if you have any questions, we might not have time for questions this afternoon. We have so much material to cover. But if you do have any questions and want to follow up afterwards, we'd be delighted to accommodate. So the sale of assets is always under scrutiny, and in this economic climate, the more so. Directors, of course, are under a number of duties and face a number of issues that can arise when dealing with company assets, and can face misfeasance, fraudulent trading, wrongful trading claims and the like for getting things wrong with asset sales, giving rise, for example, to unlawful distribution declarations, sales being reversed, constructive trusts being created, and damages claims being pursued, and various other permutations and consequences. Tonight, however, is about the sale of assets by professionals charged with their disposal, and in particular about receivers and administrators. So we've called tonight's talk Selling Assets at the Right Value, and that title was deliberately provocative because it suggests, if you read it literally, that there exists such a thing as the right value. Of course, the courts intervene when there is a sale at the wrong value, which is an undervalue reached by way of a failure of process leading to a sale at a price which is less than the best price reasonably obtainable in the circumstances. As anyone who is familiar with the sale of assets in any context, insolvency specific or not, it's all but impossible to get two people, much less two lawyers, to agree on whether a given asset has been sold for its true value. So if there is such a thing as the right value, then it can only be understood as the price obtained for an asset where an insolvency practitioner takes all of the right steps. And that, of course, raises the question we're going to discuss this evening: what are the right steps? So the goal tonight is to provide an answer to that question, at least in overview, by reference to authorities and lessons learned from experience. Can I just return to those three cases that I started off with, which were going to appear again and again this evening, just so you have a fix on them. So in Devon Commercial Limited in the Bristol District Registry of High Court, I acted for GVA Grimley LPA receivers, including their former chairman. The case went to a full trial, which I'm pleased to say that we won, with an order indeed for indemnity costs against the claimants at the end. And they attempted to get to the Court of Appeal, but that was rejected on paper in a fairly lengthy paper judgment. In Davy against Money, which if you look at the reports you will not see me referred to, I was indeed acting to start with for some many months for the individual claimant. But she parted company with us fairly early on because we had been acting for James Money of BDO in a highly successful action called reallocation, and she did not think that we might take all the points firmly. Sorry to say that she changed teams and then she promptly lost her case completely. In One Blackfriars Limited, I was acting last year with Tom Poole for the joint liquidators of the company against the former administrators. We do not yet have judgment, but the receipt of this is really imminent, within days. Obviously, we can repeat submissions that we made in open court, but we give you the talk on established principles, highlighting one or two positions up for grabs that the parties openly took. The learned judge, of course, will very shortly decide on those, and we will find the judgment within a few days in embargoed form, and thereafter it will get published. So tonight we will cover, therefore, some of the major do's and don'ts when it comes to selling assets as an IP. We will be focusing in particular on the duties of an IP acting as receivers and administrators, but many of the practical points will be relevant to IPs acting as liquidators or trustees in bankruptcy, where the rules and the context differ slightly, but a lot of what we will say tonight will be of equal application there. So I'm now going to hand over for a few minutes to James, and James will talk about the difference between receivers and administrators. James.
Thank you, Simon. Now, many of those here tonight will be very familiar with the functions of receivers and administrators. We start, however, with a brief refresher on the nature of the roles and the duties which are imposed on those who occupy them. As to receivers, they come in many different forms. Where the receiver is appointed under a lending agreement, they are known as a fixed charge receiver, and where they're appointed under the Law Property Act, they are commonly referred to as an LPA receiver. There is also a special type of receiver known as an administrative receiver, who is appointed over all or nearly all of a company's assets. Now, today, the administration has all but replaced the administrative receiver. That is in large part due to the restrictions imposed by the Enterprise Act 2002 on appointing administrative receivers in respect of floating charges created after September 2003. Administrative receiverships are therefore less common to encounter in practice, so much of what is said tonight will be focused firmly on fixed charge receivers and LPA receivers. So what is the function of a receiver? Well, as the name suggests, the primary function of a receiver is to receive property or income for the benefit of another. In some cases, however, a receiver will be tasked with selling the property over which they are appointed. And the Devon Commercial case that Simon has mentioned is a good example of that situation. The facts in Devon were that the claimant acquired a large plot of land, which at the time had one of the largest standalone bottling factories located on it. The claimant leased that factory to the Devon Cider Company, a connected company to bottle, as the name suggests, cider. The bottling company ran into financial difficulties and entered administration. As part of the restructuring, the claimant granted a mortgage of the property to a lender. The bottling business was moved to a new company, but that company also ran into financial trouble and went into administration itself. Now, the second administrator sold the new bottling company's assets to a competitor by the name of Aston Manor. And Aston Manor then went out and acquired the mortgage. So in effect, the competitor had everything but the freehold of the land, the property. Eventually, the claimant defaulted, and Aston Manor appointed the LPA receivers who Simon acted for. And the receivers sold the property to a subsidiary of Aston Manor, the competitor, for a price which meant there was no surplus returnable to the claimant as mortgagor. And the claimant challenged that on a number of grounds, including that the receivers were in a position of conflict of interest and were acting under the control of Aston Manor. Ultimately, as Simon mentioned, the court sided with the LPA receivers. The judgment in Devon Commercial has a very good summary of the duties which are owed by a receiver. In particular, it confirmed that a receiver owes fiduciary duties to the mortgagee and all others interested in the equity of redemption. The receiver must also exercise their powers in good faith and solely for the purpose of realizing the security to repay the debt. So, for example, it would be a clear breach of duty for a receiver to exercise a power of sale solely to injure a competitor. That is because that is not what security is granted for. It's also important to appreciate that you can still have a breach of fiduciary duty in the absence of dishonesty or fraud. So, for example, in the well-known case of Bristol and Matthew, Lord Justice Millett, as he was then, said that conduct which is in breach of the duty of good faith need not be dishonest, but it must be intentional. So, of course, taking a bribe would be a clear breach of fiduciary duty. While the receiver is not permitted to sell to themselves, that being self-dealing, they can sell to the mortgagee. And Devon Commercial makes clear that here the courts will treat the receiver's interests and those of the mortgagee separately. So it was not a breach of duty in that case to sell to the competitor's subsidiary, because quite simply the receiver had nothing to gain from that sale. That case also makes plain that there's no rule which forbids the receiver from putting themselves in a position where the interests of the mortgagee and the mortgagor conflict. On the contrary, the receiver's obligation is to prefer the interests of the mortgagee to the mortgagor. Finally, Devon Commercial confirmed the settled position that a receiver is subject to the equitable duty to obtain the best price reasonably obtainable for an asset at the time of sale. And later we will discuss what practical steps a receiver can take to comply with that duty. The general approach of the courts, however, is not to find a receiver in breach of the duty unless they are plainly on the wrong side of the line. If a receiver does breach one or more of its duties, then a claim can be brought directly against them for, say, breach of fiduciary duty or breach of the equitable duty of care, usually by way of Part 7 procedure. And now I'm going to turn back over to Simon to explain something about administrators.
Thank you very much indeed, James. And do remember that anybody who's joined in the last few moments, that this is being recorded, and both the recording and the subsequent note of what we're saying will be available to you either by going onto the website, or alternatively, you can ask for it and it will be sent to you. And we do value your feedback and any thoughts that you have. So as to administrators, which James has introduced me to, it's clear that, isn't it, that it's an administrator finds themselves in a very different position from a receiver. In fact, in fairly colourful terms, Finkelstein J, sitting in the Federal Court of Australia in a case called Re Opes Prime Stockbroking, gave the following summary of the functions of certain insolvency practitioners. He said the function of a liquidator is to preside over the death of a company. An administrator appointed in rescue proceedings strives for the opposite result, even though the company may yet in the end die. A receiver appointed by a secured creditor does neither of those things, being largely unconcerned about the fate of the company. From any perspective, the offices are poles apart. In this jurisdiction, the UK, the function of an administrator is slightly more nuanced. An administrator is, after all, a creature of statute and must perform functions with one of three objectives of the administration set out in Schedule B1, paragraph 3 of the Insolvency Act as amended. By way of reminder, the default position is that an administrator must rescue or must seek to rescue the company as a going concern. That's the public policy behind administrations. That is objective 1 in every sense. Objective 2 is to achieve a better result for the company's creditors as a whole than would be likely if the company were wound up without first being in administration. So, for example, it may be better for creditors as a whole if the assets of the business are sold as a going concern rather than in the kind of piecemeal sale one might expect in a liquidation. Crucially, an administrator may only pursue the second objective if the administrator thinks that it is not reasonably practicable to achieve objective 1, or they think that objective 2 will achieve a better result for the company's creditors as a whole. And generally speaking, keeping records is a crucial obligation. And you can demonstrate when challenged, or if you're in the challenging parties corner, you can seek to unveil the thinking or the audit trail behind the thinking that lay behind the choice of objectives. And that is very much a live issue. in the One Blackfriars case. Objective 3 is realizing property, selling property, in order to make a distribution to one or more secured or preferential creditors. And this is a position of last resort, in that an administrator is only entitled to pursue that objective if they think that it is not reasonably practicable to achieve objective 1 or 2. And by so doing, the administrator does not unnecessarily harm the interests of the creditors of the company as a whole. That expression again. One would be forgiven for thinking that where an administrator pursues the objective of realizing property in order to make a distribution to one or more secured or preferential creditors, that they in effect are acting as a quasi-receiver. That position, however, was firmly rejected by Mr. Justice Snowden in the judgment in Davian Money. And he said this, he said, there is a significant difference between the role of the office holder in an administration on the one hand, and in a receivership or administrative receivership on the other. A receiver or administrative receiver owes his primary duties to his appointor and is generally free to determine when and how to realize assets to repay the secured debt without consideration for the interests of the unsecured creditors or the company itself. In contrast, in deciding how to run the administration, an administrator is required to have regard to the interests of all of the company's creditors, and he can only limit his ambition to seeking to realize assets to repay the secured creditor if he thinks that it is not reasonably practicable to achieve anything else. Even then, he must not unnecessarily harm the interests of the creditors as a whole. In other words, the fact that administrators are prohibited from causing unnecessary harm to the interests of creditors as a whole means that they have wider duties than a receiver leading up to and upon sale. So in Davian Money, just to quickly run through it, the duties of an administrator were considered reasonably widely in that case, although I don't think that the principles underlying which were set out in Lightman and Moss were greatly challenged. They have been more challenged in One Blackfriars, and we will see how they are to be adjusted when we get the judgment. In that case, the Davian Money case, Ms. Davy was a sole shareholder of a company who owned a property in Tower Hamlets. She borrowed money from Dunbar to fund that purchase, and Dunbar took security in the form of a debenture and a PG. After failing to obtain planning permission for the property, the company failed to keep up with the payments to Dunbar, and they therefore appointed joint administrators. And they sold the property for less, as it turned out, than the total of Dunbar's debt. Ms. Davy brought a claim against the administrators under the Act, alleging that they had failed in their duties as administrators by favouring the interests of Dunbar over those of the company and its other creditors. She had a few arguments, most of which concerned the sale of the property by the administrators, in particular that they had, and it broke down into 4 parts. First, conducted the administration with excessive regard to the wishes and positions of Dunbar. Secondly, undertaken what was called a light touch administration, and in so doing failed to exercise independent judgment. Thirdly, failed to take sufficient steps to involve Ms. Davy in the administration and review the possibility of a funded rescue. And fourthly, that they appointed unsuitable agents, having been influenced by Dunbar, and that as a consequence, they sold the property, the sole asset of the company, at an undervalue. She alleged that the agents appointed for the sale of the property had not been independently selected by the administrators, but instead had actually been handpicked by Dunbar, the creditor. So to summarize, in the judgment, Mr. Justice Snowden accepted that an administrator owed the company, among other things, a number of duties and positions: a statutory duty to select the statutory objective of the administrator, a statutory duty to perform their functions in accordance with one of the 3 statutory objectives I told you about, fiduciary duties to act in good faith, loyally, and for proper purposes, a statutory and fiduciary duty to exercise independent judgment, a common law duty to exercise reasonable care and skill, and an equitable duty to obtain the best price reasonably obtainable in the circumstances. In the subsequent case of Brewer and Iqbal, before ICC Judge Briggs, he confirmed that an administrator also owes a fiduciary duty to consider relevant and not irrelevant matters when performing functions. A note on procedure, how you get there. You heard in relation to receivers about the typical Part 7 claims that would give rise to the claim and the action. With administrators, where a shareholder or creditor is dissatisfied with how an administrator has conducted administration, then the procedural route is to bring an application under paragraph 75 of Schedule B1 of the Act. It doesn't create a new head of liability, but instead provides a summary method, laughingly so called, since we had a 25-day trial in One Blackfriars, by which the administrator may be rendered accountable for breach of duty. And if the application succeeds, the court may order the administrator to repay, restore, or account for money or property, or contribute a sum to the company's property by way of a compensatory payment. I'll now hand back to James, who's going to introduce that One Blackfriars case I keep mentioning.
Thank you, Simon. Well, as the name suggests, the trial in the One Blackfriars case is centered around the One Blackfriars development, which you may have seen by Blackfriars Bridge. It's relevant to tonight's topic because one of the central allegations in that case is that the development was sold at an undervalue, although, as Simon has said, judgment is still pending. The joint liquidators allege, among other things, that the former administrators improperly agreed with the senior secured creditors to conduct a light touch administration, in the sense that the administrators would treat the senior secured creditors as the only stakeholders. They would adopt those creditors' realization strategy, and they would work with agents appointed by those creditors to sell the site on an unconditional basis to see as much of the senior secured debt repaid as soon as possible. One of the interesting and important issues that has arisen in that case is the extent to which the court should afford administrators a degree of latitude when it comes to things such as selecting the purpose of the administration, which Simon has explained, and secondly, the steps taken to achieve that purpose. So to what extent does the court give respect to the administrator's commercial judgment? Now, in One Blackfriars, the former administrators argued that Davian money should be understood as holding that the decision as the statutory objective is only capable on grounds of either lack of good faith or irrationality. The joint liquidators disagree. Undoubtedly, it's true that IPs are often confronted with challenging situations involving a variety of stakeholder groups, and those situations are ones in which the IP is sometimes required to make difficult and urgent decisions. So no doubt there's always a risk that a mistake will occur. However, it is true that the Enterprise Act 2002 was designed to afford greater protection to unsecured creditors than they enjoyed, for example, as a receiver. And the joint liquidators have argued, among other things, that the prohibition on causing unnecessary harm to the interests of creditors as a whole invites greater scrutiny from the court, both as to the choice of statutory objective and also the methods adopted. The former administrators say that is inconsistent with Davian money, and again, the joint liquidators disagree. Now, those here will no doubt be familiar with the judgment of Mr. Justice Millett, as he was then in the Reed Charney Davis case. There he held that the standard of care required is that of an ordinary skilled practitioner, and that to show a breach of duty to obtain the best price in the circumstances, it must be shown that the administrator made an error which a reasonably skilled and careful IP would not have made. Mr. Justice Millett also said that the administrator's duty was to obtain what the administrator perceived to be the best price, and that an administrator is not to be made liable because his perception is wrong, unless it is unreasonable. Now, that issue was not subject to argument in Re Charnley Davies, and of course it predated the Enterprise Act 2002. And in particular, it predated the administrator's duty to avoid causing unnecessary harm to the company's creditors as a whole. The joint liquidators have argued that a more intensive approach is required under the new regime, and we will see whether the court agrees when judgment is handed down. I'm now going to turn back over to Simon, who will address you, among other things, as to information gathering.
Yeah, thank you. So, as we just heard, of all the duties mentioned, the most important one is, perhaps unsurprisingly, the duty to obtain the best price reasonably obtainable. It's at the core. As explained by Mr. Justice Millett, as you heard, in Re Charnley Davies, he described that as an obligation which the law imposes on anyone with a power, whether contractual or statutory, to sell property which does not belong to him. So whatever hat an IP wears, if they're selling assets belonging to another, then this is a minimum duty that will be engaged. The other duties, of course, play a complementary role. And the thing that's obvious is how overlapping and intersecting all these duties and the satisfaction of them are. So we'll turn to the second half of this talk, which is now down and dirty, practical. What are the steps that IPs should consider when selling assets? And let's start with information gathering. One of the first things that an IP should do after appointment is ensure that they have, or will be able to have, as quickly as possible, all of the relevant available information in order to make them able to make the right decisions. So an IP's obligation to gather information is an aspect of its duty to obtain the best price reasonably obtainable for an asset at the time of sale. So, for example, in another case called Michael and Miller in the Court of Appeal, Lord Justice Parker stated that the need for the mortgagee to exercise informed judgment in exercising his power of sale in turn means that a prudent mortgagee will take advice, including, where appropriate, valuation advice from a duly qualified agent. And that applies equally to receivers and administrators. Moreover, as fiduciaries, it's incumbent on receivers and administrators to take into account relevant matters, which include gathering sufficient information to carry out their respective functions. So again, in that case of Brewer and Iqbal, and the administrator was held to be in breach of his common law and fiduciary duties in failing to seek appropriate advice as to the value of electronic programming guides, the menu of scheduled shows that one sees on the telly, before selling those assets. In the case of an administrator in particular, as we mentioned, one of the things an administrator must do early on in the administration is select the statutory purpose of the administration. It can be changed, but it's got at all times to be justified. In the One Blackfriars case, we argued that it was implicit within an administrator's duty to think that they must act rationally, which in turn requires them to be properly advised. Moreover, we said the statutory language impliedly limits pursuit of the third objective, that was the long stop, sell, to circumstances where no return can be made to unsecured creditors, which means that an administrator must, where required to, gather sufficient information to ascertain whether a return could be made to unsecured creditors before determining that the relevant assets should even be sold in order to make a distribution to secured or preferential creditors. In terms of how an insolvency practitioner should go about getting a sense of the value of the relevant assets, in some cases it may be possible to rely, at least in part, sometimes in whole, as the facts fit, on valuations that have been produced pre-appointment by, for example, shareholders, directors, lenders, obviously. An IP would be well advised to review those valuations, for it's a common charge in undervalue claims that one valuation or another has been disregarded by an IP. However, as we will discuss later, some valuations that have been commissioned pre-appointment may need to be treated with care. Important questions to ask include: who has this valuation been prepared for? What was the context? What were the assumptions? What were the special assumptions that the valuer asked to raise? And what was the quality of the valuation itself? What was the status of that valuation? In most cases, the safest course will be for an IP to commission, for example, in property cases, an independent red book valuation, which is the highest tier of valuation classes, or equivalent solid valuation of assets in question in other non-property based cases. Obtaining a valuation of this kind is all the more important where the insolvency practitioner is selling or thinking about selling a unique asset, or an asset in a specialist market, or a developable, partly developed, or convertible asset. That could even be a financial asset. That is clearly shown in the case of Brewer and Iqbal again, where the court held that the administrator was in breach of duty in failing to understand the specialist electronic programming guide market. Notwithstanding the obligation of an IP to gather information, in One Blackfriars, it was submitted that the value of an asset simply might be determined by what is achieved in the market when the asset is sold. The market will set the price, as opposed to relying on the theoretical value based on red book assumptions as to the price that you should be aiming to get to and the reasons why. And by laying emphasis in the way that I have, I've defined what the debate is that the learned judge is now considering on that very question. And indeed, we submitted that that latter approach that was let the market decide is inappropriate and too risky for an administrator, and hence any IP. We submitted that a formal valuation is more than simply a means of ascertaining what can be achieved in the immediate market. It's also a means of ascertaining the potential future value of an asset, or giving yourself arguments to argue up the value of an asset. As we shall look at later, administrators, unlike receivers, are under a unique obligation to consider taking advantageous pre-marketing steps to improve the value of an asset before sale. Evaluation gives you more than just a valuation. It's an important part of an insolvency practitioner's toolkit when marketing and negotiating the sale of an asset. And the extent of this will be determined by the judge in the One Blackfriars case. We posited at least 4 potential direct and indirect uses to evaluation. It can firstly inform an IP as to whether to set a guide price, and if so, at what level. Secondly, evaluation can inform an IP as to where to set incentives, for example, when negotiating a fee structure for a sales agent to get the best out of the agency process. Thirdly, evaluation can provide equality of arms, in that purchasers will often have one of their own and may use that in order to drive the price down. And what do you do if you don't have one to argue to the contrary? Fourthly, evaluation can assist an IP in determining whether or not a marketing and sales process has actually been successful, whether you've got to your market. Not to mention providing the IP with something on which they can rely should it actually become necessary to defend that process if it's challenged. So generally speaking, if you want to sell an asset, then you must take, obviously, reasonable steps to understand its value. That raises the question of, can you rely on others and other professionals? So IPs will invariably need to rely on others when carrying out their functions. This could be lawyers, it could be marketing agents, sale agents, valuers, and the like. That reliance is necessary, not least because in many cases an IP will be under great pressure to get the job done as quickly and efficiently as possible, and possibly as cost effectively as possible. And there's also a perception that an IP can insulate themselves from liability by delegating tasks to suitably qualified third parties. More on that later. Not only are there good practical reasons for an IP to rely on others, but there are many cases where an IP failing to do so could be considered by a court to be in breach of a duty. As we've already mentioned, an IP might be in breach of a duty for failing to seek valuation advice. However, an IP must also be careful when relying on others. To take an extreme example, an IP who relies on an obviously incompetent or unqualified sales agent or the wrong choice of agent will open themselves up to an allegation that they have been negligent. The same is true of an IP who relies on an agent whose own interests conflict with those of the IP's principal. Back to Brewer and Iqbal, the administrator relied only on the valuation advice of the directors who ultimately purchased the relevant asset and that was held to be improper. In Davian Money, Mr. Justice Snowden said, the essential question in all cases will be whether the agents to be appointed are competent and able to discharge their fiduciary duties to the company. So observable, auditable, firstly, competence, and secondly, ability to discharge fiduciary duties are essential prerequisites when an administrator is considering relying on other professionals. Where one is concerned with a receiver, the position is relatively straightforward in that the receiver can ordinarily rely on professionals who have acted for the mortgagee. That is because the receiver's primary duty is to the mortgagee. As the learned judge in Devon Commercial Property said in his judgment, it is very convenient for receivers who at the outset of the receivership have no immediate cash with which to pay bills to ask the mortgagee solicitors for legal advice. The mortgagee solicitors will have all the relevant documents and be fully up to speed, and therefore will cost less than any newly instructed firm, and the cost will probably be paid directly by the mortgagee in any event. That in a receiver's case. However, the position in relation to administrators can be more complex, at least where it is possible that there may be a return on sale to unsecured creditors. In particular, secured creditors will usually be interested in a quick sale, which will see themselves repaid or paid a portion that they're content with. Unsecured creditors and shareholders, of course, may wish to hold out and take additional steps to improve the realizable value for an asset, that they're at the end of the value chain. In Australia, the courts have indicated some disapproval of solicitors advising secured creditors and then going on to be appointed by administrators. In this jurisdiction, however, Mr. Justice Snowden explicitly held in the Davian Money case that there was no hard and fast rule against an administrator relying on or appointing professionals who have previously been engaged by secured creditors. However, it's worth noting that Mr. Justice Snowden did say that there may in general terms be good reasons for an administrator to consider holding a competitive tendering process for agent roles in such cases, and that the facts of each case would vary widely. So in some cases, beauty parades of that kind will be possible, and in others, time pressures will preclude them. While there's no hard and fast rule against an agent who previously acted for a secured creditor being relied upon by an administrator in a potential conflict situation, the position is less certain where the agent continues to act for the secured creditor. Is it permissible for an agent to act for both at the same time? Well, we submitted in One Blackfriars Limited that the decision of Mr. Justice Henry Carr in Zinc Hotels was on the point on this issue. In that case, an application was brought to appoint additional concurrent administrators in order to represent shareholders' interests in respect of a proposed sale of a number of Hilton hotels. One of the arguments advanced by the shareholders was that the existing administrators were conflicted because the firm of solicitors upon which they relied were acting for both the administrators and secured creditors at one stage in the administration. While Mr. Justice Henry Carr held that there was no strict bar to the same firm of solicitors acting for both insolvency practitioner and secured creditor, he noted that once there appeared a real possibility of a surplus for shareholders, it was recognized that there was then a potential conflict between the interests of the lenders to have their secured debt repaid and the duties of the administrators, which also involved taking into account the interests of unsecured creditors and shareholders. In the One Blackfriars case again, we argued on behalf of the joint liquidators that the former administrators were in breach of duty in relying on agents who continued to act on behalf of the senior secured creditors. In short, the argument was that an agent who acts for two principals with potentially conflicting interests is in breach of the obligation of undivided loyalty, and in particular, what Lord Millett referred to as the double employment rule in Bristol and West Building Society and Moffat. By that logic, the agents relied upon by the former administrators were unable to discharge their fiduciary duties, which of course include the no conflict rule. And it followed that the former administrators not only could not shield behind those agents, but were in breach of duty in appointing them in the first place. Among other authorities, the judgment of Rees-Zinc Hotels was relied upon. Now, against that, the former administrators have argued, amongst other things, that that case of Rees-Zinc Hotels didn't establish any strict bar on an administrator relying on an agent who also acted for the senior secured creditor in a potential surplus situation. They also argued that there was no potential conflict on the facts, and if there was a potential conflict, it was extinguished by the administrators agreeing a fee ratchet arrangement with a relevant agent, which they said sufficiently incentivized that agent to get the best price reasonably obtainable. It's expected, therefore, that the judgment in the One Blackfriars case will provide clarity on the circumstances in which it will be appropriate for an administrator to rely on agents who have acted or continue to act for secured creditors. So if the first do in this talk is to seek appropriate expert advice where needed, the first don't is to avoid relying on professionals whose competence and or loyalties may call the administrators' own and decision-making into question. That, in essence, is the point which the Code of Ethics for Insolvency Practitioners makes when it states that when an insolvency practitioner intends to rely on the advice or work of another, the insolvency practitioner should evaluate whether such reliance is warranted. The insolvency practitioner should consider factors such as reputation, expertise, resources available, and applicable professional and ethical standards. So, relying on others, James, can this be a shield?
Well, there's certainly a perception that so long as an IP relies on someone who's reasonably competent, this will provide a defense to an undervalue claim. However, it's certainly not that clear that such reliance will shield an IP in every case. Indeed, insofar as receivers are concerned, it's settled law that the equitable duty to achieve the best price reasonably obtainable is non-delegable in the sense that the receiver's duty extends to ensuring that reasonable care is taken by an agent or professional advisor employed by them. In effect, this creates a form of strict liability on the receiver. So in Raha and Austin Gray, it was held that it was no defense for a receiver to say that they had entrusted the sale of an asset to apparently competent professionals. Now, the non-delegable rule is long-standing, and in Cuckmere and Mutual Finance, Lord Justice Cross, then in the Court of Appeal, said that the rule arose out of the need to achieve justice between the parties in the days when the mortgagor did not have a direct cause of action against the mortgagee's agent. So by holding the mortgagee responsible, this ensures a remedy to the mortgagor, and the mortgagee can in turn recover from the relevant agent. In Davian Money, Mr. Justice Snowden considered whether the strict liability rule extended to administrators, and he concluded that it did not. And this was essentially because the company would have a cause of action against a negligent agent, and so there was no need to make the administrator strictly liable. However, that first instance conclusion was challenged by the joint liquidators in One Blackfriars for a number of reasons, not least because Mr. Justice Snowden had not been referred to the judgment of Lord Justice Kitchen, as he then was in Glatton Sinclair. That judgment expressed some doubts about similar reasoning in respect of court-appointed receivers. Further, the unusual fact of the decision in Davian Money, if it is correct on this point, is that administrators would seemingly be subject to less stringent duties than mortgagees and receivers. And that is notwithstanding that they all share the duty to obtain the best price reasonably obtainable. And second, the Enterprise Act places a number of additional statutory duties on administrators, which were ultimately designed by Parliament to improve the position of unsecured creditors as compared with receivership. So time will tell whether Davian money will be followed in this respect. Turning back to the steps that one can take, the next step to discuss this evening is improving the value of an asset before selling it. Now, that duty is largely unique to administrators. In particular, it's settled that both mortgagees and receivers can sell the property in the very same condition in which they found it. They do not have to wait for an increase in value, and they do not have to effect any improvements. And that was confirmed by the Court of Appeal in Sylvan Properties and RBS. So there it was suggested that the defendant receivers were under a duty to pursue planning applications for the development of the relevant properties in order to obtain the best price reasonably obtainable. And the Court of Appeal rejected that argument in clear terms. However, in doing so, the court noted that an administrator, as an agent of the company, owes a duty of care to the company in the choice of time to sell, and by parity of reasoning, in the decision whether to take appropriate available pre-marketing steps which are calculated to achieve the best price in the circumstances. So in Davian Money, Mr. Justice Snowden cited that passage with approval and said that it was consistent with the changes which the Enterprise Act was intended to bring about. In his words, the administrator cannot simply decide to sell the company's assets at a time to suit the interests of the secured creditor, if by doing so he causes harm to the unsecured creditors, which is not necessary, deriving from the unnecessary harm prohibition, for the protection of the interests of the secured creditor. The interests of the unsecured creditors therefore receive enhanced protection in an administration compared with a receivership. So pulls apart indeed. If there are steps which an administrator considers are likely to increase the overall return, then they would be well advised to consider or pursue those steps, even if the secured creditors wish for a quick unconditional sale. What that means in practice will of course vary depending on the nature of the asset. Where one is dealing with real property, often it means looking very closely at planning permission. While the secured creditors may drag their heels, the statutory regime does give administrators the power to raise funds from other sources. So at the very least, administrators should explore alternative sources of funding where there is a large potential upside to creditors as a whole from a given or proposed improvement. Whatever course an administration takes, it's a good idea to document any cost-benefit analysis so as to defend the course taken. With that, I'm going to turn over to Simon, who's going to speak about marketing.
I am indeed. Inevitably, a key step that any IP will have to take in performance of their duty to obtain that best price reasonably obtainable thereafter is to ensure that the asset is properly and fully marketed. So, for example, graphic example, in the Cuckmere brick case, the mortgagee was held to have been in breach of duty for failing to mention that there had been a planning permission obtained, which would almost certainly have increased the selling price. In another case called Bishop and Blake, Sir Francis Ferris held that a mortgagee was liable to account for failing to take care to achieve the proper market price of an inn for sale. The relevant advert had been inserted at the last minute. It had failed to include elementary contact details. The judge found that the contract of sale was entered into before, as he called it, even the most alert reader of that publication had a realistic opportunity to respond. If only all cases were as clear as that one. In Glatt and Sinclair, the Court of Appeal stated that a receiver should obtain marketing advice and advice on the property market generally, and should not rely solely on a valuation on an open market basis. There are a number of offers in that case, a number of offers were very quickly received when the property was marketed at the price reflecting an open market valuation. The purchaser was able to flip the property at a substantially higher price a few months after completion. These decisions apply equally to receivers, and with even greater force to administrators given their wider duties. Back to the sorry case of Brewer and Iqbal, the court found that the administrator's failure to understand the nature of the electronic programming guides and their true value, as I've told you about, led to a failure to properly market those guides to a potential special purchaser, i.e. a purchaser who will pay a higher price for a particular asset. The court also found that the assets had not been exposed to the market for a sufficient period of time. The explanation given by the administrator for that was that he'd been advised by the directors that if the assets were not sold quickly, the electronic programming guides would be switched off by Sky. The judge found that relying on the advice of the directors in that way was evidence of serving two masters and failing to act with loyalty to the principal, namely the company. So we can see that if an IP fails to obtain the requisite information in the circumstances, such as potentially a valuation, and places, in another instance, improper reliance on agents or advisors or the wrong source of information, then this can lead to a flawed marketing process. So in practical terms, an IP should ensure that they've retained agents upon whom they can reasonably and observably reasonably rely, and should use the independent valuation as a cross-check or benchmark by which to assess whether marketing has been successful. Gives rise to the issue of overage, or sometimes known as anti-embarrassment provisions in a sales contract. And an IP would, in our view, be very well advised to consider including such a clause. The aim of such a clause is obviously to prevent criticism of that IP should the purchaser manage to plan out, develop out, or more extensively or otherwise predictably find an unfulfilled route which they can fulfill to a higher value of that asset, or flip the property quickly for a much higher value than they had obtained as the sales process of the IP. So it's a particularly good idea where the IP is firstly confronted with a range of valuations, and secondly, where the assets belong to a specialist market or is unique or has yet to be fully realized. So those are some ways of protecting the decision maker, or conversely challenging the process by which a price is being realized. What happens if the process is found to be at fault, gives rise to those forms of loss or compensation that the court can grant. Ordinarily, this will be the difference between what was achieved in the market compared with what would have been obtained if the pre-sale and sales processes were properly conducted, as the court finds. It is no answer, I'm afraid, for an IP to rely on the market value actually achieving, as it's only where a property has been properly exposed to that market and competently marketed that it can be said that the price actually achieved is cogent evidence of the open market value of the property. You've heard this evening a lot of information. Let me try and recap in a practical sense. Therefore, recapping, whether an IP wears the hat of a receiver or an administrator or indeed a liquidator, they will be under a duty to obtain the best price reasonably obtainable for an asset on sale. Such practitioners are well advised to take steps to understand and document what exactly their process is going to be, what exactly they're selling it, and how best they believe at that time should be the process to sell it. An administrator, however, has wider duties than a receiver in that they must avoid causing unnecessary harm to creditors as a whole if a sales process that is triggering objective 3 is to be proceeded with. In practical terms, that means an administrator may be required to delay the sale of an asset and take advantageous pre-marketing steps to increase the asset's value, such as in obtaining or investigating obtaining planning permission. Again, if necessary, an administrator should seek appropriate expert advice as to how the value of the relevant asset might be improved. However, an administrator's wider duties means that it needs to be most careful and more careful than a receiver when relying on third parties to perform their functions. As we've said now a number of times, the forthcoming judgment in One Blackfriars will shed some light on the circumstances in which it is permissible to rely on agents who have acted or continue to act for the secured creditors, and the circumstances in which an administrator can shield behind the mistakes of others. The judgment in One Blackfriars is also likely to provide guidance on the circumstances in which a court will intervene in the decision-making process of administrators completely. It remains to be seen whether the approach in Davian Money and the Pre-Enterprise Act 2002 approach in Reed Charnley Davies will be followed. Thank you all for listening very much indeed. And as I've said at the beginning and during this talk, you can find the recording of this online shortly after this talk has finished, and we will be making available the notes, which will be downloaded onto the website as well. If there's any problems, do get in touch with our clerks, and if there's any feedback that you'd like to pass through, or indeed any questions that you'd like to table even at this late stage, please feel free to do that, and James and I will try and give you the answer or clarification that you seek, or learn from any improvements that you can make. Apart from that, we'll all have to wait to see what the judge says in One Blackfriars, which, as I've said, is imminent. Thank you very much indeed for listening, and wish you a good evening. Good night.